Um, well, welcome everyone to our session today. This session is entitled Community and Indigenous Freshwater Rights, Improving the Development and Environmental Outcomes. And thank you for joining us in this journey today. So just briefly, I'd like to introduce myself, and then I'll introduce our panelists, and then we will hear from each of our panelists. And we'll reserve a good chunk of time at the end of the session for questions and answers and discussion. I ask you to use the chat function in the Pathable website to enter any questions that you might have, and we can ask those at the very end. We won't be stopping between speakers for questions. We'll wait till the end to hear those. So my name is Allison Aldis. I work for the Nature Conservancy, and I lead our freshwater community-based conservation program. With me today are three speakers who we've worked with over the last couple of years. First, I'd like to introduce Nick Fromhertz, Toby McGrath, and Ruth Meinson-Dick. I'll show a slide in a minute with each of their affiliations. And we organized this session to really highlight the importance of tenure security and rights to freshwater resources that are held by Indigenous and local communities around the world who have the ability, capacity, and responsibility for managing freshwater resources. And we found that, and this is highlighted in the literature, that when local, traditional, and Indigenous communities hold the rights to managing their freshwater resources, they're better able to achieve outcomes that are successful for both human well-being as well as for positive conservation outcomes for communities. And so I will share my screen. And I hope that everyone can see this. Sorry. Just to introduce our three speakers to you today. So first we'll hear from Nick Fromhertz. He is the senior attorney and adjunct professor at Lewis and Clark Law School's Global Law Alliance for Animals and the Environment. And he will be giving us a bit of a freshwater rights 101, as well as addressing some work that he and his colleague, Erica Lyman, have done to explore the freshwater rights circumstances in Colombia, Ecuador, and in Angola. Then we'll hear from David McGrath. He's the Deputy Director from the Earth Innovation Institute and also from the Federal University of Western Pará in Brazil. And he will be speaking about freshwater rights in Brazil. And then finally, we'll hear from Ruth Meinson-Dick, who's the Senior Research Fellow at the International Food and Policy Research Institute. And Ruth will be sharing with us some thoughts about how we advance tenure security for Indigenous and local communities. So thank you very much for joining us. And we'll start off by hearing from Nick. And so I will advance to Nick's first slide. And Nick, please begin.
Okay, thanks so much, Allison. And let me continue on a note of thanks for TNC in general for organizing this and for the other panelists that are here with us today. And of course, everybody who's taken the time out of their busy schedules to listen and to interact with us for a few minutes. So what I'm going to try to do in 15 minutes is kind of break down at the 30,000 foot level kind of the nature and typology of freshwater resource rights, and then sort of try to explain, again, 30,000 foot level, how those rights play out in three different countries, Colombia, Ecuador, and Angola. And as Allison alluded to, I, together with my colleague, Erica Lyman, worked with TNC to do legal studies related to these rights situations in Colombia, Ecuador, and Angola, and you should be able to find those papers on the website. So with that, I think we can advance to the next slide. Okay, so the place to start is to try to unpack what we mean by freshwater resource rights. And actually, before we even get there, let's just unpack a little bit what we mean by freshwater resources. When I say we, I mean, this is the definition we used for our studies. I think it probably is the case for other folks working in this area, but I shouldn't presume that too much. When I talk about freshwater resources, or if you take a look at our papers, we're talking, of course, about water, freshwater specifically, right? So not salt water. But then we're also talking about other living resources. So primarily fish would be, commercially and I suppose socially the most important resource. But then also in some circumstances, aquatic plants, might be pretty important. So that's what we mean by freshwater resources, or FWRs. What do we mean by rights? What are the rights that we're concerned with? And here, the place to start is with this notion of a bundle or package of rights. And this is a term that's familiar to folks working in the land law spaces and other real property spaces. And it basically reflects the idea that it's not monolithic or singular. Instead, when we're talking about freshwater resource rights, we have a multifaceted bundle or package to consider. Now, this bundle really breaks down into two primary categories. And I believe Ruth is also going to discuss this a little bit in her slides as well. So first we have use rights. Now, use rights, as the name implies, I think, include withdrawal rights. And what we mean by that is actually, taking out the water or the fish. You might draw a distinction a little bit with exploitation rights, but for our purposes, we're kind of saying withdrawal and exploitation are synonymous. The less obvious one, though, the first one you see there, is access rights, right? In order to withdraw, or exploit a resource, water, let's say, you need to actually be able to get there, right? To get to the river, or to have access to it, perhaps through an easement or another conveyance. The other main category is control rights. Now, this really is different in kind, but it interacts with the use rights. So first we have exclusion rights. So one can imagine an indigenous community that has communal property rights or water rights to a stream flowing through the ancestral lands. Well, does along with that come a right to exclude others from using that resource? That's an exclusion right. Take the same scenario, we've got our next subcategory, alienability or transfer rights. Let's say a community communally has title or rights in a certain water resource. Does that necessarily mean that that community can transfer those rights to a third party? So can the community sell those rights to a company? Maybe not, right? That's a separate sort of dimension or way that a right can exist. And then finally, here we have management rights, which is probably the broadest, but it's the ability to make decisions regarding allocation, regarding permitted uses, prohibited uses. We could think in the fisheries context about sizes to avoid catch of juveniles. We could think about prohibited species, gear and technique rules, etc. So does the rights holder in this case, if we're thinking about an indigenous community or other local community, have rights to participate in that management scheme. Now, the third kind of bubble here on the right-hand part of your screen might be considered part of control rights, but it's sort of sui generis, and so we kind of put it to the side, and that is access to justice or legal recourse. So here, what we're talking about is the ability of a rights holder to go to a court or a tribunal or some other institute that provides potential legal recourse in the case of a perceived violation of any of these more core rights. And then the last two kind of, I guess, earth tone colored bubbles there at the bottom reflect the idea that we tried to, and we would encourage others to, think sort of bifocally about the source of these rights in law. So of course, we've got our formal or codified law. Does it appear in the state's water law or the state's environmental law or indigenous peoples law as written? But also, does customary law have something to say about that, right? This is the unwritten law, use and customs built up over time that may be especially strong in areas where local communities and indigenous peoples live, and conversely, where the state is actually minimally present. So we got to consider sort of both of those sources of law and how they interact. Okay, we can go to the next slide. All right, so if the previous slide sort of mapped out at 30,000 feet kind of what we mean by freshwater resource rights, especially in the context of indigenous peoples and local communities, can we get a little bit deeper, and can we discern certain principles or characteristics that one might associate with a legal system that is supportive of community-based management of freshwater resources in a way that's both socially just and environmentally responsible? Are there certain benchmarks or sort of characteristics that we would look for when analyzing a legal code, customary law, etc.? What we tried to do was we looked at the literature in general regarding community-based management of natural resources. And when it's sort of writ large like that, there's just a lot more literature out there. And we tried to adapt then what we identified as these sort of key principles or characteristics to the freshwater context. In the papers, you can find a much longer list. This is just an excerpt. And so among other benchmarks or key characteristics, we would look for things like some clear space that allows for local management or local participation in management of freshwater resources, right? Some sort of subsidiary space. Probably also a specialized regime recognizing indigenous people's rights, and perhaps other special communities like Afro-Colombian communities, Afro-Ecuadorian communities in the case of those two countries. We probably want to see also something incorporating free, prior, and informed consent. And maybe we'll talk a little bit about more of that in the Q&A. I think that'll come up in other panelist discussions as well. Use prioritization, right? Water and other freshwater resources are finite in nature. There are conflicting claims. Is there a use prioritization scheme that's both clear and fair, right? So that indigenous peoples and local communities aren't always at the bottom of that scheme. Is there a conflict resolution system that's clear, that's hopefully independent from other forces? We also want to see a clear rule for science-based decision-making, right? Incorporated into the law. And going along with that, some acknowledgement that the precautionary principle should apply in cases of uncertainty. So those are some of the key characteristics we look for. Probably we shouldn't think of these as a set of characteristics to be applied woodenly. How they play out or make sense in a country like Colombia may be very different than how they should play out or make sense in a country like Angola or South Africa, or pick your country. Okay, we can advance to the next slide now. So let's take a look then briefly at how this sort of scheme and these benchmarks play out or are reflected in Ecuador, Colombia, and Angola. Again, for purposes of time, I'm really kind of cherry picking here. In Ecuador, something that's interesting is the Constitution recognizes a fundamental human right to water. Now, while that sounds profound, and it is, we also have to recognize it's limited in scope, right? Talking about water for domestic uses that are really just absolutely essential, drinking water, other limited domestic uses. But nevertheless, that's in the Constitution, that's important. There's a clear scheme governing priority of uses. And what's really interesting, I think, and important is that the notion of ecological flow, right? It's the idea that you've got to preserve some kind of flow in the river so that the river can be a river, is in that scheme, and it's above industrial uses. That is pretty important in litigation that we've studied. I'll mention the case here in a second. The Constitution also recognizes that nature has its own rights. Ecuador is pretty famous for being a pioneer in this area. And nature is defined as spaces where life exists and reproduces. So that lends itself really well to rivers, lakes, and such. Now, in a case which we mentioned in the study, citizens use this rights of nature provision along with the ecological flow concept and some other legal concepts in the law to stop a proposed dam. So we're seeing that these provisions have some teeth in Ecuador. The law also embraces free, prior, and informed consent. It's a little more on the consultation to try to get to consent end of things. Problems definitely abound in implementation.
2 minutes.
Okay, thank you. I'm going to speed up here a little bit. In Colombia, we do not see as clear of a acknowledgement for an ecological flow or similar in the priority of uses. However, there is an ability for regulatory authorities to say, well, in light of environmental considerations, the normal priority needs to be altered. Rights of nature has been embraced by the courts, not written in the Constitution, but has become effectively part of the Constitution. And the FPIC problem or situation, I should say, is kind of similar. Angola is different. So in Angola, one thing that's interesting is that the right to use water for local subsistence uses is free, right? So it's free of charge. And it's primarily managed or governed by traditional authorities. So there's that customary law point. And those common uses, which are free, take precedence over other uses which require a license. Again, big questions regarding implementation. And we'll go to my wrap-up slide. So just to keep this really basic, I think, two big takeaway points from which everything else can flow. The law matters, of course, with how freshwater resources
wrap up.
Okay, are managed and how rights are enjoyed by communities. It's important to pay attention to these principles that we've identified because they can make a difference. And then, of course, implementation. That's key. Having law on books versus having a good system in practice are always two different analyses. We shouldn't forget that. Thank you.
Thank you so much, Nick. So now we'll go to David McGrath. So over to you, David.
Thank you, Allison, and thank you also to Nick for an excellent presentation, and I'm looking forward to Ruth's. And thank all of you who are here participating in this session. The title of my talk is Infrastructure Development and the Rights of Traditional Peoples to Water and Fisheries Resources in the Tapajós Basin, Pará, Brazil. I should also note that I have 6 other colleagues that participated in this study, but for time and space, I'm representing our group. Next slide, please. I mean, the big question that we're discussing and the big issue is that the Tapajós Basin is undergoing rapid change as large-scale infrastructure development impacts the river system with consequences for access to water and fisheries resources. Our question is, how do these changes affect the rights of access and use of water and fisheries resources by traditional communities? Next, please. So the objectives of the study are to analyze the legal basis for rights of access and use of water and fisheries resources, understand how these legal instruments interact with livelihoods of traditional populations of the Tapajós Basin, evaluate the capacity of traditional peoples to organize access and use of these resources as the Tapajós Basin is transformed. This study is based on literature review, a review of the legislation on access rights to water and fisheries resources, and 2 short case studies, Pimentel in the Upper Tapajós and Solimões in the Lower Tapajós. Thank you. Next, please. So here's a picture of the Tapajós Basin. You can see up at the top, it's very light, but that's the Amazon River and where the Tapajós River interacts at the town of Santarém, which is sort of visible here. So we've distinguished 2 major regions, the lower Tapajós up in the upper part, where one of our case studies is located, is an old area of European settlement right back to the beginnings. Large traditional population, most of them organized in reserves in this area. A strong influence of liberation theology, resulting in well-organized communities and a tradition of community management, and fairly ready access to key government agencies because this region is close to the capital of this whole basin, Santarém, up in the far right corner. The middle and upper Tapajós basins are quite different. They were isolated from the Amazon River to the north and from Brazil to the south for much of history. Only in the 50s, 60s, and 70s has this begun to change significantly, and especially now. The region is the focus of infrastructure development, dams, waterways, highways, and railroads designed to move commodities north towards the Amazon River where there's an international port. The regional population is in flux, migrants moving in, land speculation increasing. The result is increasingly diverse communities with limited organization. These areas are also have limited access to government authorities because they are much more distant and communication and transport much more complicated. Thank you. Next, please. We can think of these sort of following on Nick's comments of 2 sort of traditions. We can think of sort of customary rights as being sort of enshrined and supported by the Brazilian Constitution of 1988. Other key pieces of legislation or rules are the Convention 169 of the International Labor Organization, a major reference here, the UN Declaration of the Rights of Indigenous Peoples. And what these bodies of law and thoughts provide a basis for recognition of the rights of traditional and indigenous peoples. This is sort of an essentially defensive posture, conserve, protect livelihoods and rights. On the right, we have statutory law. That is what is the other formal legislation that Nick referred to of the Brazilian legislation. And here we're really dealing with 2 pieces of legislation. The water resources legislation of 2007, the federal version, and then each state has their own version, and fisheries legislation of 2009, also with the federal version and then state versions. Next, please. So for water resources law, they take an integrated river basin management. The origins of this approach, I think, come from a French tradition. You have a river basin and sub-basin committees. Committees provide basis for a participatory approach to river basin management that allow for the participation of different stakeholder groups and allow them also then to manage the river basin and also to have some say in infrastructure development. There is also a mechanism for concession of use rights with payment for water used. The law recognizes the rights of traditional communities to the subsistence use of water resources and does not charge a user fee in their case. On the other hand, it should be noted that the state water resources law has not yet been implemented, and there is no plan in place for the Tapajós Basin. The second body of legislation is the fisheries legislation of 2009. This is federal law, no explicit recognition of fisher rights to co-manage local fisheries, which is a bit surprising because there was a parallel tradition in federal law of co-management of local fisheries. So how this got left out of the law is something that deserves some investigation. Management responsibility is shifting from federal to state governments. The federal government in the last few years has decided to get out of the business of managing fisheries and pass that on to states. Some states had a tradition of doing this, others not. The state of Pará recently signed a decree that creates a mechanism for recognizing intercommunity fishing agreements. This occurred at the end of our study. So its impact on on the communities we're studying has not yet begun to take effect. But now the state government has the capacity to legalize community fishing agreements within their territories and to provide support for enforcement and other elements of defending their resources. Next, please. We have two case studies. Two traditional communities exemplify the situation of their respective regions. Community of Solimoens in the lower Tapajós, a well-organized community located within an extractive reserve. The reserve has a management plan with rules for water resources and fisheries. They have good access to government agencies to support enforcement and address other issues. And they've also negotiated a regional fisheries agreement, and that has been awaiting legal recognition for some time and could be legalized under the new law that was passed the end of June. Pimentel in Upper Tapajós is located within what was essentially outside the zone of interaction of Brazil and the Amazon. Is a more diverse community, large influx of migrants, limited organizational capacity as a result of this diversity and flux. Land tenure status is unclear. Boundaries are not respected by land speculators. The community has a protocol that was recently produced with rules for consultation, but they are having little or no success in engaging the actors who are impinging on their territory and resources. Government agencies are distant and generally unresponsive. Next, please. So what are our findings and conclusions? With regard to water resources legislation, the law offers the potential to manage the transformation of the river system and impacts on traditional populations. Legislature provides legal mechanisms to negotiate water access and use. But the state water resources legislation has not yet been implemented, so no institutional framework is available to manage infrastructure and project interests of traditional communities. And this is very convenient for the development interests. By not implementing it, the participatory mechanisms that are created are not in place, and they can essentially go along and do as they would like within the constraints of the law. The state fisheries policy now offers a mechanism for legalization of community fishing agreements to regulate access and use of local fisheries, including rights of exclusion. Community agreements function internally, but lack legal basis to address threats outside boundaries. In a water system, flowing water system, upstream and downstream can be very important, despite the fact that they're outside the territory. So traditional populations have limited ability to defend their rights of access and use of water and fisheries resources from large-scale actors outside their local territories. And this is where the future holds. If we could get the water resources legislation implemented, we begin to have a basin scale framework that can begin to defend interests of traditional populations and allow them to negotiate with the other actors that are coming into the basin. Thank you.
Great, thank you so much, Toby. And so now we'll move to Ruth.
Thank you very much. My talk will follow on these two and hopefully put some kind of a little bit broader framework on it that we can then discuss how we can use this going forward. On the next slide, I have an overview. Next. That we'll talk about what do we mean by water rights and introduce the concept of water tenure. Then why is it important? And then strategies to secure water rights or tenure. On the next slide. So in terms of water rights, I think what you've heard here are really good examples of legal pluralism, that there are multiple sources of water, of rules and law. And the legal pluralists tend to use the term law a lot more liberally than just what is on government statutes. But so you have international law, you have state law, local and customary law, and also it's important to think about religious law and even project regulations, all as having an effect on people's rights to water. These are overlapping. So at the same time and place, there are international laws that apply, national, local, religious, but I sometimes think of them as force fields. The strength of each of those is not equal, and it varies over time and place. Each of those types of law is only as strong as the institutions that stand behind it. And I think we've heard from Toby, for example, about how enforcement isn't necessarily following from having the law exist. On the next slide, we already heard about the bundles of rights, and there are different ways of breaking these up, but the key thing is that a lot of times people, when they're talking about rights, have this notion of ownership, of having all of the bundles. And that's actually rare even for land, but certainly less common for water. However, the concept of water tenure may be a more suitable one for emphasizing the complex relationships between people over water. On the next slide, Stephen Hodgson has a paper with FAO, and there is actually, I hope some of you are attending the other sessions that are talking about these concepts, but water tenure as the relationship, whether legally or customarily defined, between people with respect to water resources. And it's being used as a way to extend the debate about beyond water rights. What that lets us start to think about are the concepts of tenure security. What's the completeness of the rights? What's the duration, the robustness? How much can it withstand challenges? And the relationships among those. Next. So why does this matter? If we think about anything, the duration over time, if you don't have secure tenure, you don't have the authority or the incentive to make that investment in the construction or operation and maintenance. But if you think about it over space, you need to have some kind of coordination, often collective action at the local level, with state having a bigger role in coordination at higher levels. Next. This is so important, the importance of secure rights or tenure is something that is, when we've worked with TNC to adapt their voice choice action framework to freshwater resources, as you'll see, secure rights are central. But to have those, you also need to have strong community capacity and multi-stakeholder platforms that to link the community and state institutions. Next. What are the options for securing water rights? There are various forms of international law, the right to water. We've heard about the UN Declaration on the Rights of Indigenous People, Ramsar Convention, Treaty on Wetlands, and then national law. A lot of countries have some form of public trust doctrine, priority uses, which may include environmental flows, and then community or collective action, which can advocacy and protests, or local water governance. All of these are options for securing water rights. And each of them can have their uses, but none of them alone will achieve the kind of tenure security we envision. Each is incomplete, and they're nothing without implementation and enforcement. So on the next slide, what leads to effective implementation? Well, to have that, you have to have a match between the rules and local conditions, and both the technical conditions and the socioeconomic conditions. Barbara Schreiner, who was very much involved in the implementation of South Africa's water law, which is held up as one of the, most progressive water laws ever, has commented on how it was unenforceable because they didn't have the technical capacity. They didn't have even enough, engineers, enough knowledge about the amount of water, let alone the, the socioeconomic conditions to bridge between the different groups. So, it's bringing in an ideal water law will not achieve much. You also, effective implementation is more likely if you have consistency between the different authority structures. The work of Eleanor Ostrom and many people working on the commons has shown that monitoring and graduated sanctions are really important for implementation. If you only have huge sanctions saying that you're going to be totally cut off from water or enormous fines for your first infraction, it's probably not going to be implemented. And especially if you don't have incentives for monitoring. The other thing about effective implementation is if people internalize the rules, and that then reduces the amount of external enforcement you have to do.
2 minutes.
So, okay, good. So in particular, when you appeal to people to cut back on their water uses during droughts, for example, that may be more effective than just having external enforcement. On the next. Yes. So for the reform options, you can't just import the models. You have to adapt them to local conditions. You have to look at both formal and informal institutions. I've heard of people talking so much about a policy lever, and that's the wrong analogy. We have to move. So Ostrom and others have moved from social engineering to talking about crafting institutions. I think we need even more organic analogies of gardening, and hybrid systems. Also pay attention to path dependence. Where you have been affects where you will go and how. So identify what is there, what do people find acceptable, and build from that. The final slide has some resources, and there are other sessions going on here. I look forward to a lively discussion now. Thank you very much.
Great, thank you so much, Ruth, and thanks to all our speakers. And so now we have some time for questions. And there have been a few questions that have been typed into the chat, and I encourage participants to continue entering questions there. But we'll start with the first question. And this comes from Katie Lackey. Would protection, conservation, and quality fall under use rights? Access and withdrawal makes sense, but the quality of the water being accessed or withdrawn seems important too. So oftentimes we sort of focus on water quantity, but this brings up the important issue of water quality. So maybe we could start, Nick, if you wanted to start off with that question.
Yeah, and hopefully I'll answer it, or at least engage with it directly. I think this question raises the important point that we have rights on the one hand, right, which we tend to think of as legally backed claims to something, right? Usually something positive that people want to be able to enjoy. So talk about rights to access, rights to withdraw, to exploit. Then we have obligations on the other hand. And in law in general, this is a pretty kind of familiar dichotomy, right? With rights come obligations. What's interesting, well, I should just finish up with that obligation point. When we talk about anti-pollution measures, contamination control, and things of that nature, we're largely kind of using the language of obligations, right? You have an obligation to refrain from polluting. You have an obligation to refrain from discharging without a license or without a permit, right? If we're thinking about industrial applications. But going back to the right side, if we get into the management space, it is kind of an interesting space of convergence, right? Because communities can manage the resource by having certain water quality standards, right, that are part of exercising their management rights can be through water quality standards. So it's kind of a converging place between rights to do something that the rights holder wants to be able to do, and then obligations to refrain from certain action. I don't know if I fully answered it, but hopefully that contributes something to the question.
Yeah, great. Thanks, Nick. And we can come back also to the issue of water quality a little bit later if that is appropriate. Next, I think we'll go to this a question from David Hebart Coleman. In many Indigenous communities, there's also a sense of obligation. So would these fit on the customary side of the equation and connected to the different types of control rights? And so maybe, I don't know if either Nick or Ruth or who would like to address that question.
I'd be happy to let Ruth or Toby take first crack at that if they'd like.
Oh, I go? Me?
Okay,
All
sure.
right.
Yeah, sure. Why don't you, Toby?
All right. Well, I'm not, yeah, but I think on the issue of control, but maybe this is more related to exclusion, really. The fisheries regulation, the co-management policies that are put in place by the government don't allow exclusive access. They essentially treat the water, I say it's like they're applying navigational law to situations in which you are extracting. You're not just traveling through the region, you're actually reducing the quantity of the resource that is available. So this is a mode of contention, obviously, between a community that has made rules and would like exclusive control, and then a government which refuses to give them access control and says, no, you can make the rules, but if people obey the rules, they can fish there. Well, that's not much of an incentive for somebody who has been spending a lot of effort in making sure there is an abundant resource, and yet anybody can come in and access that resource.
Great, thanks so much, Toby. Let's switch to another question, Ruth. This one will be for you. So what can we do to decolonize data collection, analysis, and sharing processes to ensure the research process upholds the rights of Indigenous participants beyond inclusive participation? Any ideas there?
Yes, very good point. And I'd have to look up exactly where these are. There are some documents that have been written by certain Indigenous groups about the standards that they would set for different kinds of data. But I think the important point is to find out what are the issues that are of concern for communities, and how can research contribute to meeting some of those concerns. Certainly, I mean, with land rights, one of the things that some colleagues have done is, collecting data about perceptions of land rights, but then also going in and presenting communities with then information about what the legal framework is and what they would need to do in order to further secure their rights within the statutory system. So there's a lot to be negotiated, but I think the important thing is, what are the questions that would benefit the communities, and how might they want to engage?
Great, thank you so much, Ruth. So now I'd like to ask a question, just a sort of a general question, and I'd like for each of you to think about an answer. And so for many participants on the call work with Indigenous and local communities around the world to support their use and ability to manage freshwater resources, and whether those communities be traditional, Indigenous, or local communities. And so based on the research and the knowledge that you have, each of you, what would be the one or maybe two things that you would recommend that practitioners or conservationists could do to support the freshwater resource tenure security of those communities? So maybe we'll start with you, Toby.
That is a tough question. I was hoping you would start with somebody else. I think it's actually, I would like you to start with somebody else.
Okay.
I need to get primed for this one.
Okay. Maybe we can go to you, Nick. Are you volunteering?
I was, and maybe not to sort of discredit my own answer, but I think it's a real answer. It's a genuine answer, but I'm sure there's valid critique of it as well. So my answer is a typical kind of lawyer's answer, I guess, which is I'd like to see, more local communities working with allies force the issue in courts. Again, I say that's kind of maybe a typical lawyer's answer, but I'd like to see lawsuits brought, using the mechanisms that the law allows, and try to force the issues in the courts when communities feel like their rights are not being satisfied, or there's been a violation of those rights. I think a lot of court systems or other, kind of legal recourse mechanisms aren't necessarily up to the task, right? And the results won't be what we would want or what we might expect just reading the laws or learning about the place of customary law, et cetera. But I think if the issue is not forced, and if we're not sort of doing that stress test, then we don't know where we need to respond. And again, as maybe a typical lawyer, I just think it's really important to have, competent, independent, and courageous and justice systems, kind of writ large, that are capable of doing that. And I think we kind of have to force the issue. So.
Okay, so lawsuits from Nick. What about you, Ruth?
One of the things I've been trying to do over the years of working on water rights is try to make the case to policymakers of why it would be important to confirm stronger water rights. And the other part is to make visible the whole range of living law that there is. And that's where I have a great deal of admiration for the legal anthropologists and others who say, look, there is already sophisticated water rights in many communities. You look at Nepal, these different flumes, and say, yes, those are water rights based on the investment that individuals have made in those communities. Trying to say, look, there is a lot more there than many people think, and it's a good thing for people to feel like they have secure water rights. And what then we can talk about what does it take to get there.
Okay.
I'm ready to try on that one. I think I like the lines that has been taken, especially by Nick, because I think this is one thing. For example, community management. The aquaculture interest came up with the fact that you could basically rent a lake or rent a water body. And communities weren't doing that. And I said, well, you're having all this trouble trying to get people to respect your rights. But if you were to go via this more conventional legal way, you could gain the right that would be defendable and much more defendable in the legal system and ability to negotiate. And so that's one. Another was the example of gold mining that is affecting the Mundurucus reserve now, where they're putting in, what do you call it, miners, placer miners are going in and putting in, tearing up the alluvial soil, sediments of the rivers, injecting mercury and basically destroying the capacity, the water quality from the perspective of use and access. So you're losing access. And it's, well, okay, there's environmental law of environmental crimes that could be accessed for this to go after these gold miners, rather than depending on your rights and your traditional rights, but say, okay, what can we do that has teeth that we can do in a concrete way to defend our rights? And I don't see these traditions, this option of moving from traditional approaches to understanding your own internal resources to saying, okay, let's get good at using the law, the conventional law, to defend our interests, our traditional interests. And I think that's an important area that could be better explored.
Okay, great. Thank you so much, Toby. So let's go to another participant question. How do different policies of different MDBs on engagement and support of Indigenous peoples fit into the support and development of local rights beyond FPIC? For example, policies at the World Bank. So does one of you feel, would one of you like to tackle this question about development banks?
I could give it a shot.
Great, thank you.
Back many years ago, we had a process of they were putting in or asphalting the BR 163 highway from the soy regions of Western Brazil to the international port in Santarém. And they were just looking at an export corridor. We went through this area and talking to people and stuff and realized they weren't necessarily against asphalting the highway, but they were against an export corridor. They wanted a development program. And so we worked and with sort of multi-stakeholders, but mostly the grassroots organizations along there, along the highway, pulling them together, got their proposals, and were able to put together a plan that got the attention of the federal government, got the attention of the World Bank for a participatory approach to developing major infrastructure projects. And it got some traction. The president of Brazil at the time, Lula, was a big supporter of it in his first government. In his second government, he decided that he needed less of this touchy-feely stuff and more straight economic development. But for a while, it had an influence as an example of how, you could join these two projects and have an influence at the World Bank. We know how these things go over time, but it was an interesting experiment, an experience for that region.
Yeah, great, thank you. Any other thoughts about development banks, Nick or Ruth? Anything you'd like to share there? Okay. We have 3 minutes left in our session. I would love to give each of you a minute to just share any final thoughts that you might have, any, sort of big picture take homes, learnings, ideas that you'd like to move forward, anything that you would like to share with our audience at the end of this session. So maybe, Nick, can we start with you?
Sure, yeah, and I'll keep it short this time. I think that the sort of idea of necessary but not sufficient is an apt way to think of legal codes relating to water. So, I do think it's important to study what the law has to say. And I think when we do that, we should definitely have this legally pluralistic and sort of wide lens perspective. But then we need to recognize, right, that, and I think this does dovetail hopefully with what Ruth and Toby have said, right? Having, a really good, progressive, well-studied sort of legal framework, it isn't enough. I think it is, necessary, but it's not sufficient, right? We need institutions, we need people to know their rights, et cetera, et cetera. So.
Great, thank you. Thank you, Nick. Toby?
I think a lot of work I've been involved in is sort of starting from the ground up. We're starting with community agreements, and then we're saying, okay, how can we get these recognized by the law, and what happens to them when they are? Because the government will pick and choose. And sometimes they will throw out critical elements of the law, like you're not allowed to exclude outsiders or something like that. So it's a long-term process, and it involves building up institutions, building up local capacity, and negotiating, and it just goes on in this process. But I think you can get somewhere, but it really does require working with communities to build up their capacity, finding out how you can get access to the legal resources you need. In Brazil, you have the public ministry, which is a very important resource for defending the rights of local communities against other groups. So it's, I think there's a very strong ad hoc element to this, where you're sort of making it up as you go along.
Great. Thank you, Toby. And Ruth, how about from you?
I think it's an idea whose time has come now, and we're seeing greater attention to this from, for example, the FAO and the voluntary guidelines is trying to address water. So it's complex, but it's so important now that I'm really encouraged that there will be more attention to how to secure rights for communities to their water resources. And I
Great.
appreciate this opportunity to talk about some of those strategies.
Great. Well, thank you so much to the three of you. Thanks to all of our participants. And I look forward to continuing on this journey with all of you.
Great. Well, thank
Thanks
you very
for
much.
organizing it. Yeah.
All right.
Thank you.
Wow.
All right. Nice to have met all of you here.
Yes.